inside joke.
Good afternoon and welcome to the April 11th meeting of the Civil Service Commission. Can we have roll call, please?
Commissioner Manukian.
Here.
Kazarian.
Here.
Gregorian.
Here.
Yantis.
Here.
And Devine.
Here. What's next, please?
Minutes.
Move to approve and dispense from reading.
Second.
We have unanimous consent? We do. Next item, please.
Oral communications.
I have no cards. Is there anyone in the audience that wishes to address the Commission on items not on the agenda? Seeing none, we'll move on, please.
Recruitment and examination status report.
Mr. Doyle.
Mr. Chair, members of the Commission, this is a note and file item. It's simply a summary of our recruitment activity amongst the staff. As has been the way the past few months, moderate level of recruitment. We still have a relatively tight hiring freeze, but there are some exceptions to that, which you see on this report. And the report illustrates the recruitments at the various stages, dates of the exams, and ultimately when we anticipate an eligibility list for each of these. So if you have questions on this, I'll be happy to try and answer them.
Do you have any questions?
I do a couple of them, actually.
Okay.
If I'm looking at the right thing, the workload status report, the last page.
Yes.
The question I had is hourly city worker GIS technician. What does GIS stand for?
GIS stands for Geographic Information System.
Okay, and when that says, I suppose that means vacancy 1, correct?
That is correct, yes.
And the date was opened for recruitment February 6th?
That's correct.
And the date was closed March 9th?
Right, that's the close of the filing period.
Okay. I note that some of the others, such as the one before, the police officer recruit positions, have written exam and a performance exam date coming up, whereas the others do not. Are those for any particular reason, or we don't test for these positions?
Mr. Chair, Commissioner Manukian.
Manukian is fine. Manukian is fine.
Wait.
I'll take Manukian.
Kazarian, my apologies.
It's okay.
When this report is prepared, we typically will list the dates of the various processes that we know of at the time.
Okay.
My sense is that for some of these where there is no date listed, we don't yet have a date scheduled. So, Mr. Kwan is here, who is the analyst for police, and he could perhaps enlighten us on that.
Mr. Chairman, members of the Commission, with regards to the hourly city worker GIS technician, they're in the process of currently reviewing applications, and once the applicant pool has been determined, then we'll go ahead and move forward with testing. But as Mr. Doyle stated with regards to the examination dates, we're still currently accepting applications for the positions of police cadet, as well as police communications operator lateral transfer. So once the applicant pool has been determined and once we've closed the recruitments for those, at that point we'll go ahead and set the test dates.
Thank you, Mr. Kwan. If I may, I believe you stated that the lateral transfer was still accepting applications for police communications operator?
Yes.
Did you mean that, or did you mean the police communications operator? Or you did mean that?
Yes, sir.
With respect to the police communications operator, I see that there's no date opened either at all. Is that because?
Well, the reason why we haven't established a date on that is because we're in the process of examining the examination process for that.
Okay.
We're actually looking to change the written examination process for both the police communications operator position as well as fire communications operator position. Once that is established, we will put that on the bulletin and then open up the recruitment.
Okay, and one last question, if I may, Chair. Some of the positions on that page do not seem to have a closing date. Is the date of the closing something that is determined based on number of applicants and then we decide to close it, or is it predetermined?
At some point, or for some recruitments, it is predetermined where we do have, let's say, a a targeted 2-week recruitment. For some recruitments, such as police officer recruit bilingual, we will have an extended period because we're looking to get as many applicants in the process as possible because of the attrition rate through the written examination, physical agility tests, and oral interviews. So for the larger recruitments, we will hold on an open, continuous basis because we do need large applicant pools for that.
Thank you very much.
I have a quick question.
Yes.
The police cadet position, is that a paid position? How does
Yes.
that work?
It is a part-time paid position within the police department. It's probably comparable to an intern position where the targeted pool is college students, where we would have them in the department working in uniform, not a police officer uniform, but in uniform, where they would be exposed to various sections of the department, ranging from patrol, where they'd work at the front desk, to helping out detectives, as well as possibly even being in the chief's office as well.
So that position, I know we've used in the previous to really recruit from as they progress. What is the minimum age requirement for a police cadet?
18.
18.
Yes.
And there is no formal training required. It's actually part of the process. Okay.
Yes, it is a entry-level position. We are looking for college students who are at least enrolled full-time within their respective school. College enrollment is a requirement for that position.
Okay. Thank you. I have no further questions.
Can I ask Mr. Kwan?
Yes, as to
how much
other
is the pay for
sections
the...
of this.
Starting pay for we do pay $13 per hour. That is the rate that we've
Really?
assigned to that position.
What's the maximum age? Just out of curiosity.
We have no age limit. As long as you're enrolled in school, you'll be good.
You have to be enrolled in school.
Correct.
What about, let's
John,
say
we
you
won't
have
pass
a
the-
law degree and you got 35 years of experience? Does that count? I don't know.
You still won't pass the background.
Oh, that's the problem.
Thank you.
Thank you.
Mr. Kwan, please don't go away.
Yes.
If I may, what is an FLSA designation?
That's with regards to Fair Labors and Standards Act, whether or not it's exempt from overtime.
I'm sorry?
Exempt from overtime.
That's what I wanted to ask next. The exempt means exempt from overtime. That means we don't provide overtime pay for those positions who are designated as exempt. Is that it?
Commissioner Gazarian, yes. FLSA exempt means, actually, it's just the opposite. If you're exempt from the Fair Labor Standards Act, that typically means you're in a managerial professional classification, and you would not be subject to overtime after working over 40 hours in an established work week.
That was my understanding. That means
Yes.
we don't pay them for working extra hours. There is no hours, so to
Right,
speak.
there's no
Right.
overtime, and that applies to pretty much all of your management, mid-management, professional employees throughout the city.
So when I look at FLSA designation for fire communications shift supervisor, that is listed as non-exempt, that means that shift supervisor will be compensated for overtime work. Okay. And,
Actually,
Yes.
you're skipping ahead here. We're going to get into those.
Oh, I
job
thought this
specs.
was part of the-
No, that's not part of this report.
Oh, it's not? Oh,
You're
'cause I
3
could-
steps ahead of us.
Oh, yeah.
Great.
I'm so sorry.
No, that's not a problem. That's great, but let's wait and...
I will wait. I apologize.
So we appreciate the question.
Sure, thank you.
Okay. Any more comments on the eligibility?
Mr. Chair, if I could just clarify, when you have these recruitments listed and there's no opening date, that typically means something we're in the planning stages of. That probably in the next week to 4 weeks, something will be open. When there's an opening date but no closing date, that means it is still open, and people can come in and apply for that position. When we do decide to close the date, typically we give staff, there's some notification. It's usually about a week's notice, and we'll close it down. And if we're able to, we'll update it on our website, just so people know to get in their applications before the final filing date. So.
Okay, any other questions or comments on the recruitment? Seeing none, we'll move on to the next item, please.
Eligible list established.
Mr. Doyle.
Mr. Chair, members of the Commission, this is, again, a note and file item. This is the eligible lists that have been established since our last meeting. For this period of time, we have 2 lists that have been established, one promotional and one open. As you can see, the promotional one is a position in Glendale Water and Power. We only had 2 applicants, and two individuals made the list. The other is an open recruitment in the Public Works Department. 88 applications, and following the whole examination process, we ended up with 11 on the list. If you have any questions about those or the processes in general, again, I'd be happy to try and answer those for you.
Any questions? Seeing none, we'll move on to the next item, please.
Revised class specification for approval, Assistant City Attorney Series.
Mr. Chair, members of the Commission, this is a revision of the class specification series for the Assistant City Attorney series. This is more or less the level of the promotional ladder below the level of Mr. Garcia within his office. You have the Deputy, Assistant, Senior Assistant, and the Chief Assistant Attorney classifications all in one specification. This series has not been updated since 2004, and we've just made a variety of changes to the specification and how it reads. There's some boilerplate language that we've been adding to all of these the past few years, customer service and ethics and things like that. But I'd say for the most part in this series, what's been updated primarily is I'd say sort of a broadening of the series. There was a lot of very restrictive, very specific language about certain elements of what attorneys assigned to various departments were doing. There's specific mention of things like land use and GRA, NPDES, code enforcement. Most of that has been sort of taken out and just broadened to make this series a little bit more generic, and it further, I think, recognizes the way the department is now organized, where you basically have a litigation section and a transactional section. With that, the series is here for your review and approval. Mr. Garcia is here. Ms. Hunanian worked on this along with him. And if you have questions, I'll be happy to try and answer them. It's with Mr. Garcia. So, Mr. Chair.
Judging from the red marks on Mr. Gazarian's paper, I'm going to let him go first. I cut him off before. And
No, that's
you're on
okay.
now.
No. It's only informational inquiry that I had. I noted that the primary characteristics that caught my attention were the assistant city attorney position required 3 years of full-time experience versus 4 years of full-time experience for senior assistant city attorney versus 5 years of full-time experience for the chief assistant city attorney. My question was, looking at the chart at the very end of that section, I gathered, and I just wanted to know if I was correct or incorrect, that we have currently 2 senior assistant city attorneys or more?
Commissioner Gazarian, it looks like 3 seniors. There's 2 in the office, 1 assigned to water and power.
Where would that be in this grid?
The far right there.
Far right? Oh, well, that says assistant city attorney underneath it, though.
Above it, it says senior assistant city.
Yes, but that's 1. Oh, there's another one?
To the right.
1 plus 2, I see. And then 3, okay. Okay, 2 of them. Okay. And how many assistant city attorneys do we currently have total?
Mr. Gazarian, it looks like
4 or more? 1, 2, 3?
I count 3.
3? Okay. 3 plus 3. And where do counsel such as general counsel, which I believe is Ms. Marino, or general for the police, and general counsel litigation, where do they fall in terms of whether seniority or hierarchy in terms of 3 years experience, 4 years experience, those positions. In other words,
Commissioner Gazarian,
under the command of Mr. Garcia, where do they fall?
That's a good question. They are not within the series because they're sort of off serving a particular function or department, but they are between, as far as compensation-wise level, it's between the senior assistant city attorney and the chief assistant city attorney.
So they're senior plus, chief minus. Assistant chief minus. All right, somewhere in there. I just want to know, that's all. Thank you.
I believe it's Mr. Garcia's intent at some point to fill the chief assistant city attorney. That's the position he formerly held prior to his appointment.
Very well.
That individual will either, depending on what their expertise is, will either oversee litigation or the transactional side, as well as the administrative staff within the office.
And these positions, forgive me if I may, these positions, are they in any way, shape, or form rotating in nature, or they're not? They are assignments, or is it something where after 5 years on this position, then, for example, general counsel for litigation ends up being general counsel for DWP or police or vice versa?
Commissioner Gazarian, it typically hasn't been how the office is run, although there have been attorneys that have moved around, and they may start in working in code enforcement and doing a lot of work with the neighborhood services section of community development, and then they may move the main office, or I think both attorneys who now work in GWP started out somewhere else. Typically, that switch is done when there's a promotion to be earned. But I don't know, maybe Mr. Garcia wants to expand upon that a little bit.
I was trying to get Mr. Garcia to come up somehow. Thank you.
Good afternoon, members of the Commissioner. Good evening, I should say. Michael Garcia, City Attorney. With respect to that question, Commissioner Gazarian, Mr. Doyle, as Mr. Doyle explained, generally as the attorneys move up, they kind of get a little bit more focused, maybe general counsel, police, or a little bit more focus on particular departments that they're working with. The code enforcement deputy city attorney position is traditionally the entry-level position for our office, and so that position, usually an attorney will move into another function within the office if there's an opening. And the other type of movement may be within somebody that's doing litigation, if there's an opening within the transactional section, will make the move over to that. But generally, as people get more senior, they end up being a little more focused in that area because they start to gain that expertise, and we need them to continue to fill that role.
Well, thank you.
I have a quick question. I'm sorry. Mr. Garcia, just a quick note. It has nothing to do with this particular item. I know on different cases, for example, you guys retain outside counsel. What is normally the determining factor? Is it depending on the individual case itself, or?
Commissioner Manukian, thank you for the question. We generally try to handle all the litigation in-house. We have 3 full-time litigators that can handle a substantial majority of those cases. Our general practice with respect to hiring outside counsel is generally 2 criteria. One, if it's so labor-intensive that we just need to farm it out because it would just take up too much of the office resources, or there's a special expertise that we don't have in our office, maybe some electrical work before the Federal Energy Regulatory Commission. We'll need to obviously, and it's in D.C., so obviously we need to have that expertise. So those are the 2 main areas. I'd say the third is if we have a conflict within our office. We will have to, maybe if we've represented an employee in a matter and now that employee has a claim against the city, then we'll have to also hire outside counsel for that as well. Thank you.
Mr. Gannis?
Mr. Garcia, congratulations again for your elevation to city attorney.
Thank you very much.
The section, there's a section here off the essential functions that's being deleted related to drafting ordinances, resolutions, motions, and other legal documents. I see there.
Moved it up, yes,
I see it here. I thought I missed it, but there it is. They just get into the broader. This is a broader drafting of what these duties are. Is that
correct? Basically,
okay. That's fine. I somehow missed it. I looked for it, but I missed it. And when we say in the law school, are all law schools, not all law schools, relatively all law schools, either accredited by the ABA or the the state, would that be the state of California?
Correct, and I think that the accreditation is usually with the ABA. So our requirement is either that they be an in-state law school, or if they're not in-state, that they be, because if they're in-state, we have a better sense within the office, within the community about the law school, and some awareness of it. But if they're out of state, we might not have that familiarity, so we require the ABA accreditation.
I don't want to mention any names. I recall there being a law school here. Glendale. Yeah, I didn't want to mention names. That was not an ABA, but it was the state of California.
I will mention it.
Thanks.
After all,
Is that correct?
I'm the
That's
dean of
correct.
another law school.
So if we had a law school in Ohio
Yeah.
that was not ABA accredited, but accredited by the state of Ohio, we're not going to accept that.
That's correct.
So I think maybe, Mr. Doyle, then under the education training, we need to say graduation from a state of California or American Bar Association accredited school of law. That's what you
Yes.
meant to say, correct?
Yes.
And I think in the beginning definition, we say from a, see that we have in there from a recognized school of law. And Glendale's recognized in Glendale, but that may be so. But should that maybe say an accredited?
Sorry, where are you reading from?
At the very beginning definition, where it says the third line, it requires graduation from a recognized school of law. Does that work for you, or does that?
Well, it does, but I think you're right. I think having more specificity is better. So if I
Again, yeah,
don't have
'cause
a problem changing it to be consistent with the other provision, which says it's either a state California law school or an ABA accredited law school.
Okay, I agree.
I'd like to be heard when you're done on that.
Oh no, I'm going to get blasted because I suppose you went to Glendale, but
No, I did not, but I'd like to be heard on that.
Okay. And I noted that in the senior assistant attorney, we were talking about, again, you don't want specific definitions when one's assigned to litigation or one's assigned to transactional, because in looking at the chart that Mr. Gazarian pointed out, there is really nobody that is a general counsel or a senior assistant attorney over or anything regarding transactional. And I know you have at least one. I know one of the lawyers in your office that's transactional.
Right.
Why she is, but I won't tell you my nickname for her, but she's tough. But tough and good, may I add. But I don't see that here. Is there? Did you not want that specificity in the senior assistant attorney, or you're not going to be dividing it up that way?
You mean with respect to transactional?
And litigation?
Correct. I think what we did take out is we took out the specific areas of law, whether it be redevelopment or land use, within each of the classifications, and put it starting at assistant, because at the assistant level, that's where we want to see, especially with respect to the transactional lawyers, to get some specialty in some areas of the law. And that's why it started there rather than where it previously was, which was senior assistant. And then as you move up, you continue to have that specialty. But in terms of transactional versus litigation, we wanted to try to get away from that a little bit.
Okay. And that works for you? You believe you can still divide is the office pretty much divided up? I know there's other areas, but litigation, transactionals, there's still that dichotomy there?
Pretty much. We technically have three divisions: transactional, litigation, and code enforcement. But a code enforcement attorney reports to Ms. Marino, and we do. And so it's really the two main functions are those two functions.
And with respect to the general counsel, is there a separate, Matt? Is there a separate class spec for general counsel, or is it part of each of the departments?
No, there's a separate classification for general counsel. It's its own job description with one.
Is it an overall one, or is there specific general counsel public works, general counsel community development?
I think
It's just
one.
general counsel. Yeah.
And what would be the difference between a general counsel versus a senior assistant attorney / assistant city attorney?
Commissioner Gantis, the position or the classification which was created a couple of years ago was a little bit more focused on a department or major function within our office, a large department where they're handling not only maybe the specialty area of that law, but a little bit more broader focus within the department. I'll give you an example, Ms. Marino, because she's here. She's the general counsel for police, and so she's not just dealing with only police issues. She may be dealing with other issues, other legal issues as it pertains to police department. So not just the search and seizure or whatever, but maybe employment issues, contract issues, that sort of thing. So they've taken on that a little bit larger role within that particular department. So we currently have 3 general counsels.
1, 2, 3, 4. Are we missing one?
4.
Oh,
I'm sorry.
is community development still? That was our next
4.
question.
It's 4.
And we still need a community development now with redevelopment gone?
Correct, we do.
Okay. I have nothing further.
You have another?
Yes, I actually wanted to make a comment with respect to Mr. Commissioner Gantis' suggestions. When I look at this definition and I see recognized school of law and membership in the California State Bar, to me, a recognized school of law meant, when I read it last night, it meant a school of law that is recognized by one of the 50 states in the United States, as opposed to a correspondence school or self-study. I would urge the powers that be to not limit it to only those who have graduated from California law schools, because at the end of the day, as you have properly placed the and, which is a conjunctive and not a disjunctive one, they would have to be a member in good standing of the California State Bar regardless. And on top of that, they would have to have their 3 years or 4 years or 5 years experience. And I'd hate to see that we would disallow a qualified candidate if the time came just because they graduated from a school in Ohio that we've never heard of, but they are a good member in good standing in California. They possess all the other qualifications, but they just don't happen to be an ABA school graduate versus a state of Ohio accredited school graduate. That's my 2 cents on that. Thank
I'm
you.
only reflecting what he had said they do.
Right.
That's what they wanted to do.
And if I may,
Yeah, and
that's been a long-standing practice that's been in place for a number of years. I don't know how long, but a number of years. And again, it reflects that we can easily ascertain the school, and obviously they're a member of the state bar, then obviously that's required. But if they're an out-of-state school that it doesn't have an ABA accreditation, we can't really attest to the quality of that school during the selection process. And so it's so wide open in the air.
I only have to say this for you to think about. We have many fine judges in the state of California who are graduates of non-ABA schools, some of whom are not even from California schools. But they happen to have been attorneys in good standing in the state of California. And everybody from the Ginny Commission to the governor's office or the electorate in some instances have put them in black robes, and they are deciding cases. I just would urge the city to consider following in that path, and I trust your judgment in the end. I'm just giving my two cents worth. So thank you.
Mr. Chair.
Mr. Gregorian.
Yes. Well, we have all these lawyers over here. I have a different. What exactly would you like to achieve with this revision? I mean, it's going to increase the quantity of attorneys over here, because in the chart we have about 20 positions, and according to the employment record over here, I have 17 staff over there. So basically, it give you possibilities to move the attorneys, from this department to other department, or what's basically the reason, for this revision? I don't have any problem. The matter of fact, I like it because it give you more flexibility of the job description. But
Two general purposes. One, as we're going through and looking through the spec as a whole, and I do have a vacant chief assistant position, as Mr. Doyle mentioned, which is I'm going to do a promotional from within my office. And as I looked at that, I noticed that it was very specific to 2 very specific job duties. You had to be an expert in land use, or you had to know litigation. And that was the function when Mr. Braden and I were the 2 chief assistants in the office, and so that worked. But it's too restrictive for what really my needs are today, and what generally the office's needs are, and not just my needs, but what the office's needs are. And we have qualified people within our office, but it was too restrictive. So that's where it started. And as I started to look through the whole spec, I noticed there were things that were duplicative. One example is that anybody who serves as the code enforcement prosecutor shall have the duties of the prosecutor and will be immune from liability. There's government code provisions for that. Well, that was listed in all the positions within the spec, and it makes more sense to just move that over to essential function. So that happened in a number of cases. So those are basically the two primary areas to make it so that it wasn't overly restrictive, with respect to appointing a chief assistant, but also to, and frankly for the other positions, because there was, the old spec had very specific limitations for transactional and litigation with respect to the senior assistant positions and the assistant positions. And I just felt that it wasn't necessary to be that limiting.
Thank you.
Okay. Any other questions? None? I do have one quick question. Under Deputy City Attorney, you indicated that was the entry-level position. And under the experience, it indicates none, whereas all the other categories have extensive experience, 3, 4, 5 years.
Yeah.
So do I understand then that a new graduate from law school without any experience at all can apply for this position?
That's correct.
Deputy.
Deputy.
That's correct.
Which is consistent, Chair, with a new graduate being given a position in the Los Angeles County District Attorney's Office or the Los Angeles City Attorney's Office as an entry-level prosecutor.
It's very common.
Yeah, very common, yes.
That means even Mr. Gaddis could apply for the job then? He has no experience?
Won't pass the background again.
But again, I'm sorry to belabor the point. The LA County District Attorney's Office or the LA City Attorney's Office do not have ABA graduation, a graduate of ABA as a prerequisite. I urge you folks to think about that one. Thank you.
Move to approve?
Excuse me, what are we approving?
The motion.
With changes?
With the proposed changes? You're okay with that?
With which changes, I think the
So
changes.
far, because the change in here being the state of California, but Mr. Gregorian, I mean, again, I'm reflecting what you, Gazarian, excuse me.
I'm Gregorian, Manukin. Why can't you call me divine? I'll be happy.
Why would you be happy with divine?
Because he is divine.
Mr. Chair, I noted two different places where there was a proposed change. One in the definition section, and the second in the education and training section. You noted the same?
My motion was with the changes.
Okay, well, getting to Mr. Gazarian's...
Mine is not a requirement.
I was going to ask you, do you want to take a motion to make that a requirement, or is that just a comment?
No, that's a comment. I am not going to sit here and have a knee-jerk reaction and impose my thinking out loud as a policy for the city attorney's office. It's just a suggestion. I know Mr. Garcia will take it to heart and think about it.
Commissioner Gazarian, we will consider it for future review. I think it's been a long-standing practice, and just to go back to the example of to distinguish between a law school and maybe a correspondence school, I seem to recall that Mr. Howard's concern at the time we did this was you could have reasonable debate about what is a law school, and so that was part of the reason why we put that in there. So, but point is well taken, and we'll certainly consider it.
Thank you.
Thank you.
Okay, are you comfortable with the two changes as outlined by Ms. Farpetian?
Yes.
Been a motion, is there a second?
Second.
I think we'll just go by, any objection?
No.
Unanimous? No.
Thank you very much.
Thank you.
Revised class specification for approval, Fire Communication Supervisory Series.
Changes were made.
Mr. Chair, members of the Commission, this again is a revision of an existing class specification series. This time it's the Fire Communication Supervisory Series. This is a position or positions within our Verdugo Fire Communication Center, which, as you know, it's a regional center which now has, I believe it's 11 cities that, gosh, they keep adding them. I can't even keep up. 13 cities.
13 cities.
But at this point, it really, the changes are not huge, but we did feel in looking at these two supervisory level positions that the communications supervisor, that's a middle management position, needed to be beefed up a little bit. And you'll see a slight elevation on those job requirements, 5 years of experience, AA degree, and such. Frankly, this is a position we have not utilized for quite some time. In the current organization, we have these shift supervisors who obviously oversee a shift, and then above that, the next level that's filled currently is by Mr. Don Wise, who's in the audience, and he's the executive administrator for the Verdugo Center. So Again, in anticipation of the need to fill this fire communication supervisor position, we're proposing some changes here on this specification. So with that, we have questions. Again, we have staff here to answer them.
I have one question at some point. Just one.
Mr. Mnuchin.
Yeah, just a quick note regarding the Verdugo dispatch. I know we've covered this in the past. We service 13 cities, and so I have a better understanding. The 911 and 911 calls that come in go directly to Verdugo dispatch, and from there they decide what city it belongs to, or is that how it works?
I believe so. I'll let Don Wise.
You can ask about what happened at the freeway fire the other day.
Oh, sure.
There were
Absolutely.
different ones that went. That's the best example of all.
Good evening, Don Wise, Executive Administrator, Verdugo Fire Communications Center, and Commissioners. Nice to see you. The 911 call arrives at the local police department first.
That was going to be my next question. So there it goes there. From there it goes to. Okay.
Exactly. And they answer the 911 call as police, fire, or medical. And if it's fire or medical, it is then transferred over to Verdugo Fire Communications for any of those 13 agencies.
Okay. And the reason being, if someone calls, let's say one of the cities that you service through the Verdugo dispatch, if somebody who's in, let's say, Monrovia, and if they're serviced, when they call 911, it goes to their police department first, then it gets transferred to you guys?
Correct.
Okay. And to pay for this operation, do they also participate in or they just get the benefits?
They are contract agencies. So Burbank, Glendale, and Pasadena are the Tri-Cities are the owners of the system, and the other agencies, the other 10, are contract agencies for a service fee.
That's all I have. Thank you.
My only question is to Mr. Doyle. Glendale City Employees Association and the Glendale Management Association, which are the two associations having reviewed these proposed modifications. I was only curious, what are they made up of? For example, the City Employees Association, is that made up of all city employees from various departments? Or the Management Association, who is that exactly?
Commissioner Gazarian, we have now 5 bargaining units here at the City of Glendale, employee associations. The two referenced here, the Glendale City Employees Association and the Glendale Management Association, both have, in this one specification, positions that they represent. The shift supervisor is part of GCA. That's a non-management position. The communications supervisor is part of the Glendale Management Association. The GCEA is really our largest employee association, and they represent really all non-management employees, non-sworn employees, so basically your employees who are part of pretty much every department in a non-sworn, non-management capacity. And most recently, our electrical and water field employees are no longer part of the GCEA. They have their own union, which is the IBEW. But the GCA does represent again, the non-sworn, non-management employees throughout the city, your librarians, your engineers, your mechanics, your clerical employees, lots of your administrative positions, sanitation workers, the whole works, as well as many of the non-sworn people who work within police and fire, your dispatchers, even your police records employees, the parking checkers, those are all part of the GCA. And similarly, the GMA is your mid-management and management level employees throughout the organization.
Thank you.
Any other questions?
Move to accept.
I have one quick. I'm just curious. You indicated all the 911 calls come into the police department. Are their operators housed in your facility, or do they have their own?
No, they each have their own facility. So each of the police departments have their own communications center, and then Verdugo is a regional combined center located here in Glendale.
So there's an immediate transfer then, even though you're not in the same building or the same room?
Correct.
for the medical and the fire calls.
Correct. It's just a one-button transfer, and they stay on the line just to ensure that there's not a police presence needed, and if there is no police presence needed, they drop off the line, and we continue on with our business and the dispatching.
I'm sorry, just a quick note, following up on our chairman's question. And the reason why police department gets it first, is it because the volume of the calls, there's more related to the police?
Correct.
Or, okay.
And I'll give you an example. Glendale Police Department received over 200,000 911 calls last year. Our call volume for our emergency lines was 128,000 for all 13 agencies. So that gives you an idea as to the disparity there. They're handling the brunt of it with all of those calls, and so they're filtering that out and just giving us the medical and the emergency calls.
Now, I know in the past, the cellular calls always went to CHP, and then it was, is that no longer the case?
That has since changed. Phase 2 technology is now allowed for that cell phone call to be routed to the police department for the most part. And there are still some older phones out there that fall under Phase 1 technology. Those go to the CHP. And then any call that is within an eighth of a mile of the freeway or on the freeway will still go to the CHP.
Okay, I see. So even if you're within the city, but you live close to the freeway, it would automatically go.
Correct. And they'll reroute that call appropriately if need be.
Thank you.
Thank you very much.
Well, before I make my motion, I just want you to stay there. I'm always amazed. I was fortunate enough to get a tour when they basically opened the Vidurgo Fire Communications Center, the fabulous center that's in our city that really saves a lot of lives and dispatches people. Like I said, for the fire on the freeway, it's not always, if something's in Glendale, for instance, if you're in the very tip of northwest Glendale, it's possible you'll have the Burbank Fire Department come to you. I know that I was with my cousin in, I think San Gabriel is one of our agencies, if I'm not mistaken. Mm-hmm. We were at lunch at San Gabriel, or in a San Gabriel restaurant, and I think it was the Alhambra Fire Department came to us because they were the closest ones that were available. So this saves a lot of lives and a lot of valuable time, and I think it goes without saying that this was a pioneer effort on our city's part, along with Burbank and Pasadena, and I want to personally congratulate you for what I think is a fabulous system that's in effect that saves many, many lives.
Thank you very much. We're very proud of our folks. This week is National Telecommunicators Week, so we honored them last night with a proclamation here in City Council, and they do an amazing job. And I'll go back to the wind event that we had on November 30 and December 1 of last year. Normally we would receive about 400 phone calls. That night for a 48-hour period, about 400 phone calls, and we received over 3,400 phone calls during that 48-hour period, processing them 93% of the time within 10 seconds, answering that phone call within 10 seconds, 93% of the time. It's an amazing feat. Not everybody can do that job, and we are very proud of them. So,
Keep up the good work.
If I can just, one other thing, one of the issues, I remember one time when we were, Matt, what were we were going over these specs before, or there was an issue regarding the job going open, that the pressure on these operators, that we have a lot of turnover because it's such a high pressure job that a lot of them, it's really difficult. It puts a lot of stress on, and are we still doing that? Are we still having a high amount of turnover in that area?
We have settled that down somewhat, and I think we've got a lot of good folks in play, but industry-wide, the turnover is amazing. Not everybody can do the job. Those folks that can multitask do the best. So folks that don't have the experience, such as waiters and bartenders who can multitask, do very well in this profession.
How about lawyers?
Yeah,
exactly.
Bang on lawyers.
Thank you very much.
Thank you.
I didn't.
So moved.
Thank
So
you.
moves there a second?
Second.
Okay. Any objection? We have unanimous consent.
Pushy guy.
Next item?
Report on POBAR and FOBAR.
Well,
Mr. Chair, members of the Commission, I'm very proud to have this presentation tonight. It was a few months ago that Commissioner Manoukian had asked that we provide some information on the Peace Officer Bill of Rights as well as the Firefighter Bill of Rights, Procedural Bill of Rights. This is a very good idea because many of the cases that you hear, many of the disciplinary actions that are dealt with relate specifically to the Peace Officer Bill of Rights, POBAR. You don't get a lot of cases in fire, and again, the Firefighter Bill of Rights is relatively new. We're still trying to sort that out, but POBAR has been around since 1977, and I mean it's an entire generation of police officers have dealt with POBAR and the rights that are afforded under POBAR, and we had a lot of information for you tonight, and at this point, let me go ahead and introduce our two presenters. Again, two very great veterans of this organization, Carmen Marino, who's the General Counsel for the Police Department, as well as Manya Hunanian, who's a Senior Human Resources Analyst. Again, Carmen works in the Police Department and deals day in and day out with all of the issues relating to law enforcement. Manya, as well, has been as long as she's been an analyst with my department, she has worked with the fire department very closely. So the two of them have a great deal of both practical expertise and knowledge on dealing with public safety matters. So with that, I'm honored to present Carmen and Manya.
Thank you. Before you get started, I'd like to suggest to my fellow commissioners that I know we're going to have a lot of questions, but to keep the flow of her presentation going uninterrupted, I suggest we hold our questions and ask them at the end of the presentation. So if we can do that. And you're on.
Very well. Good evening, Mr. Chair and members of the Commission. We can go ahead and just get started with our first slide here. And for the purpose of this presentation, we've designated certain slides that we'll each speak about, so we'll be switching on and off, both Ms. Hunanian and myself. But I'll get started. POBAR is known as the Public Safety Officers Bill of Rights, and we have used the POBAR abbreviation to designate that. This law has been in effect since 1977, so about 35 years. And in the actual legislation, in the bill, there are some legislative intents and declarations made, specifically that effective law enforcement depends on stable employer-employee relationships, among other things. But it was very clear when this law was passed that the intent was to provide for a good, solid foundation between supervisors, employers, and employees, managers as well. And the code section, if you were ever inclined to want to look at this particular statute, it's found in the Government Code at Section 3300 through 3313. Next slide. Now, in contrast to the Public Safety Officers Bill of Rights, we have the Firefighters Bill of Rights, and it's very new. It's only been in effect since 2008. So we don't have a whole lot of experience with this act, but it is modeled after the Public Safety Officers Bill of Rights, and as far as legislative intent and declarations and findings, it also has a section, and among other things, this is just one part of it. It indicates that effective protection of property and public safety depends on the maintenance of reasonable and consistent procedural protections for sworn firefighters. So that act is found also in the Government Code at sections 3250 to 3262. Now you might ask, well, okay, so we know that the legislative intent was to have stable employer-employee relationships and to provide for procedural protections for these employees, but what do these laws really do? In essence, they guarantee certain procedural protections to employees, public safety officers, and firefighters who are the subject of an investigation or who are subject to discipline. So that, in a nutshell, is what these two separate acts do. I'll turn it over to Ms. Hunanian.
All right, the next couple of slides talk about who's covered and who's not. Essentially, as far as who's covered, under POBAR, all peace officers are covered under the Act, and under FOBAR, all firefighters, including those who carry out dual functions, such as paramedic, EMTs, who are also firefighters, are covered. As far as who's not covered, if we look to our own agency, reserve officers and academy recruits are not covered. In addition, one of the differences between the two acts is that while POBAR covers probationary police officers, under FOBAR, probationary firefighters are not covered.
Now we'll get into some of the nuts and bolts for the two acts. Now, political activity is an important pastime for most of us, and there are some specific sections for under both POBR and FBOR. Essentially, firefighters and public safety officers may engage in political activities as long as that political activity occurs when they're not in uniform and when they're not on duty. Oh, one other thing, it's on the PowerPoint, but it's just an interesting note that peace officers may be members of school boards. So peace officers can participate in the political process by being members of school boards. In contrast, firefighters are not limited to just school boards. They can participate as members of school boards and a local agency, as long as that local agency is not their employer.
Okay, the next few slides cover the topic of interrogations. When a police officer or firefighter is under investigation and subjected to interrogation, which can potentially lead to the imposition of discipline, under POBR, the interrogation must be at a reasonable hour, preferably when on duty or normal waking hours, unless the seriousness of the investigation requires otherwise. And under FOBAR, it must be at a reasonable time when on duty, unless immediate threat to public safety. Also, under both laws, if the employee is interrogated while off duty, he or she must be compensated for that time.
Now we'll get into what happens prior to the time that a subject employee is subject to interrogation. So the next couple of slides involve prior to the actual interviewing of the employee. Well, first of all, they have to be informed of the individual, the name, the rank, the command of the officer in charge of the interrogation, the interrogating officer, and everyone who is going to be present sitting at the interview of the employee. Also, under both FOBAR and POBAR, there's a two-interrogator rule, meaning that only two individuals in that interview can ask the questions. That's important. Also, under both statutory schemes, the subject employee must be informed of the nature of the investigation. And prior to the interview, they have to be given a reasonable amount of notice for the date and time of the interview. Both statutory schemes provide that no offensive language may be used. Further, no promise of a reward shall be made as an inducement to answering any questions. Continuing, as far as media visits, and this may come up when you have officer-involved shootings or other events of notoriety, but an employer cannot subject an employee to media visits without express consent under POBAR. And under FOBAR, it's a little more clear that the express consent given by the employee has to be in writing. So it's the same section, the only difference being that under FOBAR it has to be written consent, and under POBAR it doesn't specify written consent. Continuing. If prior to the interrogation it's determined that the subject employee may be charged with a criminal offense, you must immediately inform that employee of their constitutional rights. This is an interesting requirement under the Firefighter Bill of Rights. This requirement is not present in the Public Safety Officer Bill of Rights. And that is, we call it the Spielbauer issue. But essentially what is required, and this is in the statute, is that for a firefighter or an employee who's covered under the Firefighter's Bill of Rights, before that employee may be subjected to answering incriminating questions, the employer has to obtain essentially a grant of immunity from the prosecution. And this has to be a formal grant of immunity. And I note the Spielbauer case there, and I do have the citation with me if anyone's interested. But essentially, this statutory language is in direct conflict with the California Supreme Court's decision in Spielbauer. And just briefly, in that case, the California Supreme Court determined that a public employee, not a firefighter, not a peace officer, it was actually a public defender, may be compelled by threat of job discipline to answer potentially incriminating questions without a formal grant of immunity. So there is a conflict here in the law, and this conflict has not been tested, so it's unknown how this path will or where this path will lead, but that's what's in the Firefighter Bill of Rights. Continuing, again, some similarities under both sections. The interrogation may be recorded, so the employee's interview may be recorded. The employee may record as well. So that's consistent in both. And if a court reporter stenographer is used, then the employee is entitled to those notes. Continuing again. We've talked about the notes. There is a provision in both sections that if the notes are deemed confidential, the employee, you may not enter those notes into the employee's personnel file. Now, for simple admonishments, for simple counseling, for routine contacts that a supervisor may have with an employee, the law is clear in both statutory schemes that the peace officer, the public safety officer, Bill of Rights, and FOBAR do not apply in those situations. So supervisor just routinely providing some counseling to an employee or unplanned contact, asking questions that's not an interrogation, then these rights would not apply. So both laws make it clear that they do not apply under those circumstances. Now, under right to representation, when an interrogation focuses on matters that may subject a subject employee to punitive action, there is a right to representation. That's pretty straightforward. The only caveat being that the representative can't be involved in the same investigation. Can't be a subject.
Okay, moving on to the investigation itself. Under both laws, the investigation and the imposition of the discipline must be done within 1 year from the discovery of the misconduct. There are, however, some exceptions, and I'd like to just go over a few of those. One is if the employer, the subject employee, voluntarily waives the 1-year statute of limitation. Two is, for example, if the misconduct is the subject of a criminal investigation, or if the investigation involves a multi-jurisdictional investigation, for example, at the federal level and state level. Other exceptions include where the investigation involves an employee who is incapacitated or otherwise unavailable, where there is a civil action, where the subject of the investigation is a named defendant, if there's an investigation involving a criminal litigation where the complainant is a defendant, and where the investigation involves an allegation of workers' compensation fraud. There's also an opportunity to reopen the investigation. An investigation may be reopened if there's significant new evidence that has been discovered that's likely to affect the outcome. Also, evidence, if the evidence could not reasonably have been discovered in normal course, or there's evidence resulted from the employee's pre-disciplinary response.
Forward, we have administrative appeals. Both sections provide that employees who are subjected to action have administrative appeal rights. It's interesting that for the firefighters, the specific provision indicates that the appeal procedure has to be in conformity with the State Administrative Procedure Act. That specificity is not in the Public Safety Officer's Procedure Bill of Rights, so that's an interesting distinction.
All right, the two laws also cover adverse comments. Specifically, an employee has the right to review and sign any adverse comment that's placed in their personnel file or any other file that's used for personnel purposes. So, for example, if a supervisor maintains a file on an employee Anything that goes, an adverse comment that goes in that file, the employee also has the right to review it and sign it. In addition, the affected employee has 30 days to respond to any adverse comment placed in their personnel file. Employees under both POBAR and FOBAR have the right to inspect their personnel files during usual business hours upon reasonable notice. And under both laws, officers and firefighters may request in writing that material placed unlawfully or mistakenly in their file be corrected or deleted. And if they want to do so, they must include the statement of reasons. Also, under both FOBAR and POBAR, an employer may refuse to correct, and they have 30 calendar days to do so, and they must notify the employee of the decision in writing. And both the request and the decision become part of that personnel file.
With respect to lie detector tests, both statutes provide that no peace officer or firefighter shall be compelled to submit to a polygraph, essentially, against his or her will. Then there are specific sections dealing with financial disclosures, and both POBAR and FOBAR indicate that you cannot require a peace officer or a firefighter to disclose income, assets, debts, expenditures, unless required by law or court order. There is a specific section involving peace officers that indicates that if there is information indicating a conflict of interest or information is necessary to ascertain the desirability of an individual for a particular specialized unit, then there may be disclosure requested for peace officers only. Then we have certain rights that apply to both firefighters and peace officers, and that's searching lockers. You cannot search a firefighter or peace officer's locker or other assigned storage space unless you've got the employee's consent, you have the employee's presence, you've give prior notification of a particular date and time, and or a search warrant. So those are the exceptions. So with respect to prior notice, if you give the employee notice that you're going to search a locker and you give them a date, maybe it's for a week or whatever the time period is, and they don't show up and you know that they have notice, well, then that would be presumed okay. Then we have a couple of issues with respect to photographs. Under the Public Safety Officer's Bill of Rights, it's very clear that if you have a photograph of a police officer and you want to use it on the internet for some particular reason, you have to let the officer know that, and if the officer believes that posting that photograph is going to endanger his or her safety or may result in a harassment threat to him or his family or her family, then that could be a problem. And if you don't take it off, there's a $500 assessment that could be levied against the employer. Now, interestingly, the Firefighter Bill of Rights is completely silent on this issue. Now, going on to remedies, and again, this is a lot of information, and we're going through it kind of quickly, but it's intended to be just a brief overview. But we're almost towards the end, and what are the remedies if there's a violation of the Peace Officer Bill of Rights or the Public Safety Officer Bill of Rights or the Firefighter Bill of Rights? An individual can seek or attempt to seek injunctive relief or other extraordinary relief. If the court were to find a violation and the violations were found to be malicious, then to injure a firefighter or a peace officer, then the civil penalty is up to $25,000 for each malicious violation found by the court. There is an attorney's fees provision. In addition, if there are actual damages that are at issue, if they're proven, then those could be awarded. They're awarded as to the agency and not an individual. So there's really no individual liability. It's against the agency. If the action is deemed to be frivolous, then of course the courts can sanction the plaintiffs, the employee, the attorneys who brought forth a frivolous action if it is so found to be frivolous. So that essentially concludes our presentation. There are a couple of other major differences that I could just briefly point out between the two acts. Probationary employees are not covered under Firefighter Bill of Rights. They are covered under Peace Officer Bill of Rights. The formal grant of immunity before compelling a firefighter to respond to incriminating questions, obviously that is not in the Public Safety Officer's Bill of Rights. Prior to imposition of discipline for firefighters, there is a 48-hour requirement, notification requirement. That's not present in the Public Safety Officer Bill of Rights. Administrative appeals have to conform to the Administrative Procedures Act in the State Code. That's not present in the Public Safety Officer Bill of Rights. Those are just a few, but they're the major differences. So with that...
Well, I want to thank you for an outstanding report. It's very concise, very clear, and with that, we'll turn to the...
Yeah, if I've been taking some notes on some of the, and thank you very much, by the way. This was very helpful. We've come across these issues. Actually, you know, up until recently, I didn't even know we had, the fire department had its own Bill of Rights. And we've come across some of these issues on some of the hearings that we've had. So this helps in clarifying some of the, how we go about handling some of these issues. Now, I want to make sure that we understand I understood correctly on some of these issues. So if, and some of these questions that I'm asking, they're not intended for any specific situation, but let's say we have a particular police officer that is under investigation. So if we want to search his locker related to that investigation, we have to give them notice that on so-and-so date we're going to search your locker? Did I understand correctly?
Lockers cannot be searched, but it's not just limited to lockers, it's assigned storage space. So if there's an assigned storage space, you have to either get the employee's consent, you have to get a court order, a search warrant, you have to give them notice, and if they are not present at that time and place...
Even if you have a search warrant?
Well, if you have a search warrant, you...
No.
That would be separate.
Okay.
Correct.
So that's different than, all right. Then financial disclosures, for example, I know several years ago the LAPD had an issue with some of their guys in the gang unit where they were asked to either provide financial disclosure or be to change to a different unit. Is that still the case?
I remember the news media coverage on that issue. I'm not sure how it ended up, but I thought that they were challenging those provisions. Ultimately, I thought that they went ahead and
well, most of them actually transferred.
That's
they brought
my
in.
understanding. So
even in today, if we have concerns about certain individual within a department, we can't force them to go on there and provide a financial disclosure, if I understand correctly.
Well, under slide number 34.
Correct.
Right. So for peace officers, an employer may request or require financial disclosure if there's information indicating a conflict of interest or information is necessary to ascertain suitability, desirability for a particular unit.
But you can't make it a blanket policy across the board. It has to be a specific situation on that there has to be concern.
Correct.
Okay. Then the next question that I had regarding the lie detector test. We cannot, if let's say an individual is under investigation through internal affairs and there's some issues that we cannot request a police officer to take a lie detector test.
That's correct.
Okay.
The employer cannot compel.
Got it. Okay, regarding adverse comments, the employee has an access to their personnel files. Is that true for all employees, or so any employee working for the City of Glendale can actually request to take a look at what's in their file?
That is correct.
But a police officer can request for an item to be removed, and does the employer have to do that? Has to remove that item, or they can? Okay. Sorry, just a couple more questions.
Yes. To clarify on that, all city employees have personnel files, obviously, and all of them have adverse comments at one time, well, not all of them, but
Sure.
when adverse comments do get introduced to the file, in most cases they're notified of that. However, peace officers have that special ability to rebut that, and they have up to 30 days to do that, and that's not available to your typical manager or rank-and-file non-sworn individual.
Okay.
It's one of those special protections that these individuals have.
Okay, just a couple more questions. The administrative appeal that you mentioned in your presentation, that's over and above the protection that they have through the civil service. I mean, the appeals that's before they get to any disciplinary action taken that could be appealed to the civil service, correct? Do I understand that correctly? The administrative appeals?
Well, the Civil Service Commission certainly has one administrative appeal that is available through a process that's already in place.
Correct. All right. And, okay, two more.
And for firefighters, just note that I don't believe we have any experience yet dealing with how an administrative appeal would work under the state's Administrative Procedures Act.
Okay.
Commissioner Mnuchin, you note from slide number 26, this is uncharted territory for us.
Sure.
Because I don't know why they did it this. They wrote the statute this way, but wrote that our procedures have to be in accordance with the State Administrative Procedures Act, which would mean either we'd have to set up some type of a special process, which I don't know if that would conflict with our charter or what, but or we'd have to go through an administrative law judge to adjudicate any type of substantial disciplinary action that affects a property interest right. We have not, the statute's been on the book 4 years, and we've not had to cross that bridge yet. But it is confusing, and I think it's unfortunate that it was written that way, because a lot of agencies either have a local border commission that adjudicates these cases. Many of them have arbitration agreements with their collective bargaining agreements. It seems like the system, a good system, is in place in most agencies. So I really, a little frustrating on that end. At some point, we'll cross that bridge when we get to it.
Okay. A couple more questions. This is regarding interrogations and interviews. At what point does an interview become an interrogation or an investigation? That's an area that's a little bit gray in my mind, and I think we've come across this on previous cases that, if a supervisor is talking to an employee, has questions, at what point does it become an interrogation? And then you have to stop and say...
That, Commissioner Mnuchin, that is a very good question. I think I need some water.
This has been the subject of an immense amount of case law.
There have been... Yes, it is an area of... it's a question that comes up frequently for many of our supervisors. The position that I take is that... Sorry. Is that if the supervisor has in his or her mind that what they're going to be asking about could potentially lead to discipline, and they've taken steps to conduct some investigation prior to speaking to the employee, then you're moving down the path of an investigation. So if there have been some steps, and there's actually some case law that has been decided, a case out of the Los Angeles Airport Police, where in that case, it's the Labio case. In that case, the supervisor actually took some steps before confronting the employee with having taken a patrol vehicle off limits to a donut shop. And so in that case, because the supervisor had actually taken steps, had done some investigation, when the supervisor actually spoke with the officer, that was more of an investigation, interrogation, and that's what the court said. So in that case, it wasn't a routine contact. It wasn't an unplanned conversation. Clearly, the supervisor had taken some steps. So It is a gray area, and I get lots of questions along those lines, so I think your question is a good one.
Okay. And the last question that I had, at the beginning of the presentation, it was my understanding that POBAR stands for Police Officer Bill of Rights, but you said Public Safety.
Yes.
Okay, so I misunderstood. So it should be Public Safety Officer Bill of Rights, correct?
Right, and that's our first slide. It's Public Safety Officer Bill of Rights. And there is a slide that indicates to whom those rights apply, but it is entitled Public Safety Officers Procedural Bill of Rights. And commonly, we do refer to it as Peace Officer Bill of Rights, POBAR, but it is Public Safety Officers.
I want to thank both of you and Mr. Doyle for an excellent presentation. It was very helpful to me. I have no further questions.
We wanted it to be short but informative and just an overview. So thank you very much for having us. It was a pleasure.
If we may go.
I didn't know where he was going, yeah.
I actually do not have any questions because, Mr. Gantis, actually this is an area that I know very well. And I have to compliment Ms. Marino and Ms. Hunanian for simplifying it as well as you folks did, because I was actually thinking I'd like to know how they're going to put this before this commission in such a very simple way, because it took me a long time to understand it in my previous pro bono endeavors in this area of law. I would like to make one comment, not a question at all, and that goes to the inquiry that Commissioner Mnookin was making. My understanding has been, and I'm not sure if Ms. Marino you'll agree with me or not, I think you will, that when a question is posed by a superior to a subordinate officer that is accusatory in nature, that is designed to or may lead to eliciting of an incriminatory response, that's when you're getting close to that POBR, area. But it is a gray area, and I agree, because reasonable minds will disagree as to the mindset or the mens rea, if you will, of the interrogator, whether he is an interrogator or is he counseling. And I've seen that in the past, that I was just counseling, I wasn't interrogating. And it's reasonable to assume one or the other, because we can't read into the mind of the person, obviously. Thank you so very much.
Commissioner Gazarian agreed completely.
Yes.
Well, following up with that particular issue, and just let me comment, Mr. Gazarian.
Yes, it's Commissioner Gazarian.
Excuse me.
Sure.
So you're happy they did a simple presentation for members of this commission. Are we supposed to assume that we needed a simple presentation?
Yes, okay. because the more complicated we make it, the more confused we'll become.
Oh, that's true, too. Yes. That was meant in jest, of course, you know.
I know.
But I do have a follow-up to that. If, in fact, there is an issue, and as Mr. Mnookin said, some of these issues we hear from time to time, on what is an interrogation. Are you being, as an officer, a public safety officer, being interrogated? What is the role of the Civil Service Commission in that? I noted that the remedies are an injunction, going basically to Superior Court. If that issue were presented to us, it would appear to me that is not necessarily an issue that we would take up in one of our hearings, of whether or not the discipline was appropriately, because it doesn't say that you would set aside the discipline. Arguably, you could, I suppose, get an injunction against the discipline, but I'm not sure that's our role. So what is our role?
Question.
That's a great question.
I'm not sure it's Ms. Marino's place to advise us, but I'm happy to get the advice.
In fact, what I was going to say, when that issue is presented to the Commission, I'm sure that would be raised with your counsel, and your counsel would advise you, based on the circumstances, based on the facts, what action you may take as a Commission when that issue is presented.
I must have, then let me rephrase the question. Is it within the jurisdiction of the administrative appeal to rule on POBAR issues, according to POBAR, as you read it?
I think any attorney presenting a case may raise the issue, and it would potentially be an issue that would be discussed.
Would it go to admissibility, Ms. Marino?
I think that it would go to evidentiary issues and maybe even weight of the evidence. Again, not knowing the particular facts that would this is all hypothetical.
It is
but
hypothetical.
I would say that the circumstances and the facts would be discussed with your counsel, and your counsel would give you advice on whether to receive the evidence, not receive the evidence, to discount the evidence because of an issue, that sort of thing.
So, but I think I'm hearing you say that it would be an issue, it could be an issue in front of us.
It depends.
Yeah. Okay.
It depends.
The interestingly enough, I had a question regarding the State Administrative Procedure Act. Matt, is that true then, that what we have set up in civil service does not comply with the State Administrative Procedure Act?
That is true, Commissioner Gantis.
So what you're saying is that we, of course, I've been on this commission over 12 years. I know you've been here forever. I know that they did have them before, but in the 12 years I've been here, we have never had a firefighter. So arguably now we may not hear firefighters. Arguably.
Yes. And again, the FOBAR has only been in effect since 2008.
Wow, that's an interesting. That could be a rather interesting issue. Can that be part of the collective bargaining of the firefighters to collectively bargain that to arbitration rather than? It doesn't appear to me that it does.
I don't think so. I think the statute says administrative procedures. So I think our hands are a little bit tied here.
Want to go back to the charter?
But the police officer Bill of Rights does allow us to do that. We could collectively bargain an arbitration procedure rather than a hearing in front of under the charter.
That would either require a modification of the charter or an interpretation of the charter, which would enable that authority to be delegated to an arbitrator. But we discussed this a few years back when
I recall
there was some pressure with the GPOA about possibly going to arbitration. And I think even under those circumstances, even if we did collectively bargain a provision requiring arbitration, under the charter, I think you would still have the final say in that. However, you would look at the decision of the arbitrator and have to either affirm or modify that.
Yeah, may I inquire? Forgive me.
Oh, yeah, I've still got the floor.
Oh, I'm sorry. As to that issue, if I may get a moment after Mr. Gantis, because that caused me some confusion just now. Go ahead. Yes.
Thank you. The FOBAR requirement, F-bar, whatever it is, that before compelling an employee to answer incriminating questions, must provide to and obtain from the employee formal written grant of immunity from prosecution. Does that mean then if they're conducting an investigation that, which are done in police cases all the time, there's no grant of immunity there, but to do that in a firefighter's case, unless you get, and we say grant of immunity from prosecution, we're talking about criminal prosecution, not disciplinary action.
Correct.
I see. Okay.
Correct.
But that's not done, but it has to be done, or you just can't investigate.
It's an interesting dilemma. It's in the statute, and it has not been tested. We have the conflict where the Supreme Court has said for a public employee, not a firefighter, this obtaining of immunity doesn't apply. So it'll be interesting to see how this plays out in the future.
Is there any? I mean, with this issue and the State Administrative Procedures Act issue, are these issues being discussed to amend POBAR to include those? Is that, to your knowledge, is that being?
I'm not aware, but I mean, I haven't heard of anything.
Let me see if I have any other questions. The issue of the employee's file, where he objects and given 30 days to object, and then the employer has 30 days to say, well, we're going to put it in there anyway. Is that appealable? Do you know what I'm referring to? I'm referring to slides 30, 31, 30, 29, 30, and 31, excuse me.
Appealable in the sense?
the employer has the final word. Employee says, I don't want it. Employer says, you do, then that's the end of it. There's no right to appeal to any body, or I guess other than maybe go to the Superior Court and get a writ of mandate against it being done.
That would be the only option, I would imagine, but
what?
there's a right to respond. There's 30 days. So, is that the section you were talking about?
In other words, the employee has a right to inspect their personnel files. They can request, the officers or the firefighters can request that material placed in the file be corrected or deleted.
Correct.
And they have to give you a reason for it. I don't like what my captain said, and I don't want that in the file. And they have 30 days to, no, they don't have 30 days. They've submitted that, and they have to give reasons. I don't like it because it misstates what is there. I don't think that what he said was factually based, etc. Now it goes to the employer, and I take it the employer in this case, if it were, let's assume it's the police, it's a police officer, that would be the chief or his designee of police, correct?
Correct.
He has 30 days to consider that request, and he says, I don't agree with you. We're going to put it in the file.
The only requirement would be to notify the employee.
And then the employee could go to the Superior. That is a writable action. Is that correct?
They could certainly try that.
Has that not been done to your knowledge?
To my knowledge, it hasn't been done. Not on that issue.
I'm finished.
Okay. Mr. Gregorian?
I have an easy question. During the hearing, especially when we're involved with the police officer, because Pobar is police officer, Bill of Right. If we find out, or commission find out that there's a Pobar violation, what's going to happen to commissioned position? I mean, it's going to affect on our decision, because definitely we have to, in a point of time we are going to find out it happened last time, that there was some violation. But nobody noticed, and then during the interrogation or the question, we find out that there was some kind of violation, because it's a kind of a very gray area. It's difficult to identify it is being violated or is not violated, or what happened. So then the position of commission, I mean, can we continue the case, or can we just disregard this point?
Again.
Did I make myself clear? Because
again, I'm not.
We're talking about the rights, but in the meantime, we have to see the effect of that rights whenever we are sitting down here as a commissioner and going through the hearings, and we have to come with some kind of a verdicts. And the main thing that we have to be very fair. Did I make my...
Commissioner Gregorian, thank you for your question. But again, from my perspective, our review was just a basic overview. I don't think it would be appropriate to comment on anything that has come before the commissioner, either previously or pending or in the future. So again, I would, on those issues as they come up, the commission has counsel, and counsel can be consulted, and advice can be sought from counsel, again, based on the facts associated with whatever the issue is that's being presented.
Yes. Very briefly, getting back to Commissioner Gantis's inquiry, whether or not you can investigate or not if you don't have a grant of immunity with respect to a firefighter. My understanding of FOBR is that, yes, you can investigate. You simply cannot utilize the admission of this subject of the investigation, or perhaps to a larger extent, I've seen it where you cannot utilize even a declaration against interest of a witness that you're trying to question with respect to the subject. Though he is a witness, you, again, cannot subject him to incriminatory statements. But you can continue to investigate. You just have to resort to other means of investigation and see if you can sustain the finding. With respect to the other question, whether or not firefighters, if the matter was to come up, which it hasn't apparently in a number of years, they can forego or they are not subject to Civil Service Commission. It is my understanding that neither are the police officers, because they can forego this process and go directly seeking judicial intervention of a finding that at the Skelly level they do not agree with.
Anybody can do that.
Right. So that brings me full circle. So any hopefully not, but any hypothetical firefighter who may be subject to discipline in the future, I don't know if I'm mistaken in stating that that particular firefighter, through counsel, may choose to bring the matter before the civil service, and the city may indeed agree that this is a proper venue. And at that point, I think it is akin to certain rights are codified, but parties can agree to operate outside the statutory provisions so long as there's a stipulation to proceed otherwise. That's my hope.
You think so?
I believe so, yes.
There's a, ma'am, Mr. But if it's mandated that it be under the state administrative, I mean, I haven't read the State Administrative Procedures Act. Is there a provision that allows that in there? That they could stipulate to go directly to court and not do that?
Well, no. If we take a comparative analysis as to the Family Law Act and certain provisions in that act, we know, I know you know, that parties can provide for outside of the Family Law Act so long as it is not contrary to public policy.
Agreed. And they can agree to anything.
Right.
Absolutely can agree to anything. But you mentioned that they didn't, that the police officers don't necessarily have, you have to exhaust your administrative rights, and that's one of those rights is civil service, so they have to go through civil service.
I disagree with you. I've seen it done otherwise.
Ben, let me say that I think we're getting beyond the scope of the presentation. We have two great experts on the law.
No, not quite.
We'll debate
it. And we're hearing that there's, disagreement between both of them. I don't think it's going to be solved tonight. I think the purpose of tonight's meeting was to hear the overall view of POBAR and FOBAR, and I think we got that, and get into deeper discussions way beyond...
After the hearing.
After the hearing.
Great.
Guys, in fact, you ought to take John to dinner.
Yeah.
I owe him more than dinner.
So, Mr. Manukian, it's a simple question.
I'm sorry?
It will be a simple question.
It will be, or you're asking?
I'm hoping it'll be.
Well, it's going to be a question. It's regarding the whole purpose of understanding this FOBAR and POBAR was the presentation. And one question that I still want to clarify, this issue of immunity regarding firefighters. So if I understand correctly, if a firefighter, now the first question is, does that apply also for criminal investigations or no? So if a firefighter is under investigation for being an arsonist, if you want to interview or interrogate this individual, you have to provide immunity?
Remember, this code section has to do with the employer asking the employee questions.
Okay.
And if there are going to be questions that may result in incriminating answers, that's when under the FOBAR, that's when the request to the prosecution for a grant of immunity would come up.
Okay, so again, so if
For criminal.
So even for criminal?
For criminal, that would be a whole
Okay,
separate
so
arena.
he would be...
Separate investigation. And when you're questioning an
But it's-
employee, you can compel them to answer questions. In a criminal case,
You cannot.
you cannot.
You cannot.
Therefore,
I'll tell you about it later.
That information that might be put forth by that employee can't be shared with a prosecution in the case of a criminal prosecution. The question about, can the employer guarantee immunity? I don't know how in the world we would do that, but we certainly wouldn't share that information with a criminal case. There's administrative and criminal has to be completely separate.
So I would say that the easiest way to try to remember this is that this is in the employment context.
Sure.
And under the criminal context, that would be
Totally
separate.
different.
So if you've got an employer asking potentially incriminating questions, that's...
Got it. Thank you. I have no further questions.
Okay, one of the nice things about being chair is usually all the questions that the chair has are answered before they get to him. This happened in this case with the exception of two.
I do.
And, however, this is just really a kind of an overall academic question, but are there similar procedures or rights for all civil service employees? If not, why not?
There are certain rights that, based on other case law, would apply to all employees. For example, the right to have a representative would exist because of a case called Weingarten. If you're a subject of an investigation or subject to potential discipline under the Weingarten case, you have a right to a representative. So some of these, that basic right would apply to any employee, any public employee. However, some of the more specific rights do not necessarily apply.
Okay. The second question, is there a nexus between Pitch's motions and these rights that we discussed tonight? I know when we hear Pitch's motions, they're generally, in fact, they're always dealing with getting into the employee's files, the police officer's files, which you touched on here in terms of the POBAR. So is there a nexus? Are the Pitch's motions and the requirements for Pitch's motions incorporated in this government code, or is that a separate issue we need help?
Thank you, Chair. Mr. Chair, the Pitch's issue is a completely separate issue outside and apart from the POBAR issues. It's a completely different statutory scheme. The Pitch's requirements are in the evidence code, and I can give you the section if you'd like that, 1043 of the evidence code, and as well as some case law, but that's separate and apart from the government code provisions set forth here.
Mr. Doyle, were you going to mention?
No, what I was going to say is what we were referring to in this presentation was the employee himself or herself reviewing his or her own file.
Okay, as opposed to an outsider getting into the
But as you know, Pitch's does only apply to peace officers.
Pardon me?
Pitch's only does apply to peace officers. So from that standpoint, it's easy to confuse that, you know, the point that might be part of POBAR, but it's, as they've said, it's a separate thing.
However, this commission, Mr. Chairman, this commission has adopted the procedures of where there's going to be motions or requests to review employee files, whether it's police officers, firefighters, or otherwise. We have adopted Pitch's procedures since that's an established procedure.
Correct.
Okay, seeing no further questions, again, we want to thank Reno. And
Thank you.
Great job.
Yes, I didn't say that. Thank you both.
Thank you.
Excellent job.
Okay, and we'll move on to the next item.
Agenda forecast.
Mr. Chair, the agenda forecast illustrates some of the items that are coming up at our next few meetings. April 25th is a meeting we may want to cancel because we do have a hearing date for one of our hearings on that same date. If I will say at this point, if something compelling comes up that needs to be dealt with in a timely manner, we'll probably go ahead and have that meeting in the middle of, probably recess the hearing and start the commission meeting. Outside of that, we'll probably end up canceling that meeting unless anyone objects to that. And then whatever items we were planning to address, we'll move those to the following meeting on May the 9th. So, I do want to point out also May 23rd, 2012, and you'll see in a quarterly basis, it'll say a report on administrative leave, and this is simply the agreement we made with the Commission to bring that item back on a quarterly basis, just to give you a head count or number of employees that are on administrative leave. And essentially, we won't give names, but just the number by department, and that would be the...
Did you say May 23rd on that?
Yes, sir.
My calendar shows that we have a 5-hour block of time reserved for a hearing that day.
Okay.
I would ask that we don't burden that afternoon further. I mean, the report perhaps could be brought over at the next...
That's one of those days that we also have a hearing. Okay.
Yeah.
Well, we'll keep that in mind. Again, we're always happy to cancel a meeting if there's nothing pressing, but sometimes there are items that are time sensitive, and we'll just play it by ear, and I'll communicate with the chair on that decision closer to the time of the meeting. That's satisfactory.
Fine.
Okay, any other questions on the calendar? Seeing none, we'll move on to the next item, please.
Reports and information, past due employee performance evaluations.
Mr. Gaddis?
Yes, Mr. Chairman. The following have no past dues on their listing: the City Attorney's Office, the City Manager's Office, the City Treasurer's Office, the Finance Department, the Fire Department, Glendale Water and Power, the Police Department, and Public Works. Out of 1,695 salaried employee count, which, by the way, that's a lower number than we've had in a while, so it looks like we're going down. We have a total outstanding notices that have not completed employee evaluations of 29, which is a very, very good number.
Thank you. Next item?
Civil Service Commission, under staff comments.
Any comments from anyone?
Nope.
I do want to make a quick comment regarding the police department. I think I'm speaking on behalf of the commission when I say that we want to recognize and congratulate them on a job well done. I guess we've all read in the paper the last week that there have been, I believe, 7 arrests of burglar people in the various areas of the city. And it was an outstanding job. I thought it was a collaboration. I think Burbank was included. The K-9 unit was included. And they did an outstanding job. And I just wanted to take a chance to say thank you on behalf of the commission and the city of Glendale.
Agreed.
Yeah, agree 100%. But one quick comment also for the public not to put their guards down, because there are still a number of ongoing situations that are continuing on that particular item. So just you have to be very vigilant, but I agree with you. That's a very good point. We should congratulate our men and women in the police department for a phenomenal job.
Okay, with that, is there a motion to adjourn?
Motion to adjourn.
Adjourn.